So good afternoon, everyone, and welcome to this webinar, 100 Days Under the New Labour Government, What Changes Does the Employment Rights Bill Provide for? My name is Fiona Herrell and I'm a partner in the Employment and Immigration team here at Brodie's, and I'm delighted to be joined by my colleague Katie Henry. Today, Katie and I are going to give you a very brief overview of the main provisions in the Employment Rights Bill. That is the Labour government's new piece of draft legislation, which was published on the 10th of October 2024. And the backdrop to that, just by way of reminder, is that in the government's, or in the Labour Party as it was then's, planned to make work pay document that was published in May 2024, it set out a whole host of employment law reforms that it said it would make if it were elected to form the next government. It also in that document said that too much time had been lost already and that they would hit the ground running and introduce legislation within 100 days of entering government. That was a commitment that was then repeated in the manifesto in June 2024. And as I said, 10th of October 2024, we then had the draft Employment Rights Bill published. So that's what we are talking about today. If we could move on to the next slide, please. What I would say, and a bit of good news to start the session, I think, is that if you were joining because you were worried that there were immediate actions you would need to take within your business, changes to your contracts, changes to your policies and procedures, to your practices, you can rest easy because there's nothing that you need to do immediately after this session. Please stay on though, don't drop off. But we wanted to get that point across nice and early in the session, because I think when we all heard that the government was going to be bringing in legislation within 100 days, we were sort of wondering what that would mean in terms of immediate next steps for employers and their practices. In reality, because of the speed with which the Employment Rights Bill has been prepared, it's just not been possible for all of the reforms to be fully fleshed out, completely detailed. And so what we see in many cases is that there's going to be further consultation. In some cases, it will be quite extensive consultation because the ideas or the reforms that are planned are complex and new, but there will be further consultation and changes to the legislation. And in fact, the government itself has already identified some changes it wants to make to the Employment Rights Bill. You might also be aware that we're in a position where we've already got 4 consultations underway. Those were published last week, and they're in relation to the application of some changes around 0 hours contracts for agency workers, in relation to collective redundancy and fire and rehire, in relation to some trade union reforms, and also in relation to SSP for low earners. So those are already underway and they're running until the first week in December. There will be further consultations throughout the course of next year. And ultimately, what the government has said is that it anticipates that the majority of the reforms will take effect no earlier than 2026. And in particular, in relation to the unfair dismissal reforms, which we're going to talk about very shortly, that they will take effect no sooner than autumn 2026. So there is going to be a little bit of time. If we can move on to the next slide, please. The Labour government has described these reforms as the biggest upgrade to rights at work in a generation. They are going to fundamentally change the employment law landscape in many areas, and we sort of categorised them through these lenses on the slide, and this is what we're going to be talking about today. So in particular, we're going to look at unfair dismissal and other day one rights. We're going to be thinking about impacts for contracts and working practices. We're going to be looking at trade unions and collective bargaining and reforms in that space, families and flexible working, sexual harassment and harassment more generally, and also fire and rehire and collective redundancies. In total, the bill brings forward 28 individual employment reforms. It is 150 pages long and the explanatory notes are over 100 pages themselves. So there's a lot of detail, even though I've just said there's not a huge amount of detail because of the speed with which the bill has been produced, but there's a lot of detail as it stands, and that detail will be added to over the coming months. So let's jump straight in, if we move on to the next slide, please, and have a look at reform in relation to unfair dismissal. And I think this is probably one of the most headline-grabbing reforms that the government had detailed in its prior documentation and its manifesto, and it's obviously made its way into the Employment Rights Bill, and that is about making unfair dismissal a day one right. So you'll be aware that in order to bring an unfair dismissal claim in the employment tribunal, employees usually need to have 2 years continuous service to be able to bring that sort of claim. The Employment Rights Bill provides for unfair dismissal claims from day one of employment, so that qualifying period will be removed. For as long as there has been unfair dismissal protection, there has always been a qualifying period. The duration of it has changed, but it has always existed. It is going to be removed. But what the government has said is that they're going to consult on a statutory probationary period to allow for there to be a proper assessment of an employee's suitability to a role. They're proposing a 9-month initial period. So that's longer than the employee groups are advocating for, the trade unions advocating for a 6-month initial period. And there'll be this concept of some sort of light touch process, which will still allow for you to dismiss fairly if the termination date falls within that probationary period, or initial period is what they're calling it in the legislation, or notice of up to 3 months is given within that initial or probationary period. And it will be the case if the reason for dismissal is capability, conduct, statutory contraventions, so it would be illegal for you to continue employing the person, or some other substantial reason relating to the employee. So you'll still be able to get to a fair dismissal, but there will be some sort of light touch process that you will have to follow before you can bring that person's employment to an end. Consultation is going to follow, including on what that fair process will look like. There's been talk about, would it just be sending them a letter? Will it be having a meeting with them? If it's having a meeting, will they have the right to be accompanied? That's how it looks at the moment, but all of this is subject to consultation. The government's also considering a lower compensation limit for unfair dismissals during this probation or initial period. So the current cap on compensation might not apply if you're dismissed during the very early stages of your employment. Now, one point to flag is that automatic unfair dismissals that currently exist, so if you're dismissed because you've blown the whistle, for example, won't be impacted by the changes. And as I said just a few moments ago, these changes in particular, the government has said will not come into force before autumn 2026. So that 2-year current qualifying period will continue until then. In terms of what do we think the changes will, what impact they will have, in reality, we're going to have a whole host of people or group of people who wouldn't normally or previously have had the ability to bring an unfair dismissal claim being able to bring an unfair dismissal claim. So we will likely see claim volumes going up. But what we might also see is a reduction in people trying to use discrimination and whistleblowing provisions for tactical reasons because they didn't have the qualifying service. So it might be that we end up with a reduction there in those sorts of more complex types of claims, but an increase in the number of just straight vanilla unfair dismissals. If we move on to the next slide and staying with the concept of dismissal, Labour government is very disparaging about the practice of dismissal and re-engagement or fire and rehire. There have been a number of high-profile cases where employers have used this sort of process in order to either bring about changes to terms and conditions of employment or to get rid of employees and to bring in other employees to do the work. And they had said that they planned to end the scourge of dismissal and re-engagement, fire and rehire, and that it must be abolished. In the Employment Rights Bill, as it currently stands, it's not been banned completely, but it is going to be very difficult to rely on the provisions in order to be able to make these sorts of changes, because what the Employment Rights Bill now says is that it will be automatically unfair to dismiss an employee for refusing to agree to a change in their contract of employment. and it will be automatically unfair to dismiss to enable the employer to employ another person to carry on the substantially same duties as the employee carried out before they were dismissed. So we're looking at automatic unfair dismissal there. So unlike at the moment where if we go through a process of dismissal and re-engagement, fire and rehire, it is an ordinary unfair dismissal claim. We've got the ability to try and defend that. We can see that we had some other substantial reason justifying the dismissal and that we followed a fair process. And ultimately, if there is an award made, we're looking at a capped claim. In the new world, it's going to be automatically unfair, so it immediately changes the risk profile, and it is understood as things currently stand that there will be no cap on the amount of compensation that can be awarded for claims of this nature. So automatically adjusting the risk for the business if they try and do this and get this wrong. There will be a very limited exception, but can't stress enough that it's very limited, and it is only where the employer can show evidence of financial difficulties affecting the ability to carry on the business as a going concern or the activities constituting the business, and that the need to make the change in contractual terms was not reasonably avoidable. And even if those conditions are met, the employer must still demonstrate that the dismissal was fair, considering factors including whether there was any consultation and whether anything was offered to the employee in return for them agreeing to the variation. Now, this is one of the areas where there is a consultation ongoing at the moment. The consultation in this space is about whether or not the interim relief remedy that exists in the employment space should extend to these sorts of claims. Interim relief being the remedy where the employment tribunal orders that your employment must continue until the dispute has been ultimately determined by the employment tribunal. That consultation is running until the 2nd of December. If we move on then to the next slide, and again, still sticking with the theme of dismissals, and this time looking at collective redundancies. So at the moment, we trigger collective redundancies if we are proposing to make 20 or more employees redundant at one establishment. So that might be a branch or it might be an office within 90 days. And often what happens is employers look at their business and the way that it is structured and are able to say, well, we don't think we need to add the redundancy dismissal proposals there with the redundancy dismissal proposals in that part of the business, because we see them as being different parts of the business. They've got different P&Ls, different management teams, and therefore we don't need to add them all together. And we're only proposing 10 in one part of the business and 7 in the others. So we're at 17, we're not over 20, therefore we've not triggered our collective consultation obligations under TALRCA. The proposal in the Employment Rights Bill is that ability to look at it per establishment will be removed, and the collective redundancy threshold will apply across the whole business rather than in respect of each establishment, which means that much more frequently employers will be triggering collective redundancy consultation obligations, whether that's electing and having employee reps in the business or engaging with trade unions if there's trade unions within that particular organisation. Again, consultation has already been launched in this space too. The government is seeking views on increasing the maximum period of the protective award if an employer is found not to have complied with its collective consultation obligations. So at the moment, it's 90 days gross pay per employee. They're thinking about one, should that be doubled so it becomes 180 days pay gross pay per employee, or actually just removing the cap entirely and allowing the employment tribunal to decide the amount of compensation that should be awarded. And they're also again thinking about interim relief and whether that's a remedy that should be made available in this space. Further down the line, we've been signposted that there will be further strengthening of protection in relation to the collective redundancy framework in 2025, and that there will be consultation on doubling the minimum consultation period when an employer is proposing to dismiss 100 or more employees from 45 to 90 days, which is what it used to be, and it was shortened. So there might be a plan to put that back up again. If we move on to the next slide, and coming away from dismissals and having a look at rights and protections for 0 hours and low hour workers. The Labour government has been very clear that they're concerned about exploitation of individuals who are working on contracts of this nature, and they're looking to give them additional protection. So these are new concepts that are being proposed in relation to those working on 0 hours and low hours contracts. And I have to say they are pretty complex, but the basic idea sitting behind them is that individuals working on these sorts of contracts will have a guaranteed hours. They will have a right to be offered a guaranteed hours contract that reflects the hours that they have worked over a reference period. It's expected that that reference period would be 12 weeks. So the idea here being that if an individual is on a contract that says that they work 3 hours a week, but over the reference period, whatever that is ultimately determined to be, they're working 10 hours every week, then they should be offered a contract that provides for 10 hours a week, not the 3 hours a week that they are currently contracted to work, albeit that they've been doing more work than that. They will, of course, be able to reject the offer of a guaranteed hours contract if that is something that they want to do. If they decide to accept it, then they'll work under that new contract or the varied contract with the guaranteed hours, but there's no stepping back from that. So once you've ratcheted it up, if you go from 3 hours to 10 hours, then that individual is then sitting on a 10-hour a week contract, and there's no way to say, well, it was for a short period of time, so we're therefore sort of going back. That becomes their terms and conditions of employment, and we would then be having to undertake processes if we wanted to make further changes to that. But then if there was a further ratcheting up and they went from 10 hours a week to 12 hours a week over a reference period, then again there would have to be this offer made and the ability for the employee to again increase their hours if that was something they wanted. Now, not all employees will want guaranteed hours or the additional hours because it might suit them for various different reasons to work in the way that they are. But to the extent that there is a concern about exploitation, this is the way that the Labour government thinks that it should be fixed. There's going to be consultation in this space on what constitutes low hours, and there's consultation already underway on how these measures should apply in relation to agency workers. But we can see that these changes might force employers and businesses to look at their ability to ramp up and ramp down their workforce as they need, particularly, for example, in businesses where there's seasonal work that's undertaken and there might not be the same flexibility that is currently available to employers in this space. On the next slide, we're just flagging that the government also intends to introduce new rights for 0 hours and low hour workers so that they have reasonable notice of shifts, shift changes and cancellations, and compensation for shifts cancelled, moved or curtailed at short notice. And again, here we're expecting that there will be secondary legislation that will set out the detail of what amounts to reasonable notice, for example, and what is a qualifying shift. Moving on now to have a look at flexible working. So we've already seen some changes in this space from April this year. The right to request flexible working now applies from day one after rather than after 26 week service, and employees can make 2 requests per year instead of 1, and the time limit for employers to respond has been reduced. Now, the Labour government had indicated that it would make flexible working the default. It hasn't gone as far as that, and there also aren't any changes to the penalties for failure to comply, which remains 8 weeks pay, currently capped at £5,600. The new rules in the Employment Rights Bill mean that an employer will only be permitted to refuse a request if it considers that one or more of the 8 business reasons applies. So those are the 8 business reasons that we're already very familiar with, and it is reasonable to refuse the request on those grounds. And an employer will need to notify the employee of the grounds for the refusal and explain to the employee why they consider their decision to be reasonable. So at the moment, you've got to handle a flexible working application reasonably, but the new changes will inject further reasonableness requirements. Not quite clear yet how that reasonableness will be determined in terms of, who decides was it reasonable to refuse the request on those grounds, because there's an argument that the employer is the best person to decide whether or not it was reasonable to refuse the request on those grounds. But as I say, more consultation will follow on that. So we'll expect some further detail on that. Moving on to sexual harassment. So we're now a few days into the new regime, which has been in place since the 26th of October and requires employers to take reasonable steps to prevent sexual harassment of their employees in the course of their employment. There's the EHRC technical guidance, which if you haven't looked at that yet, and this is your remit, then we would definitely recommend that you have a look at that. That was updated in September 2024, and it has some really good guidance about how employers might go about trying to discharge their duty to take reasonable steps to prevent sexual harassment. We could spend a whole session just talking about that of itself. And in fact, we are speaking to a number of clients about the duty to prevent sexual harassment and helping them with things like risk assessments and training for their businesses. So if that's something you need, then you should speak to your usual Brodie's contact about that. But if we turn to the next slide, then we're going to see that actually there's going to be some further changes to this new duty, even though it's only just been introduced. And so the new preventative duty is to be extended to a duty to take all reasonable steps to prevent sexual harassment. So again, raising the bar in terms of what employers are going to be required to do. It's likely that we will have set out in legislation examples of reasonable steps that employers should be taking to prevent sexual harassment. We are also anticipating that whistleblowing rules will be amended to provide that a disclosure that sexual harassment has occurred or is likely to occur will be a protected disclosure. And I think that just demonstrates the concern that there is sexual harassment ongoing within organisations, but people do not feel like they can speak up, either to say that they have experienced it or that they have witnessed it. And so giving people special protection, not just saying you won't suffer any disadvantage or detriment, but actually giving people whistleblower protection is a way to try and encourage people to really speak up when they either experience it or see it or believe that it's happening within the organisations that the employer then can do something about it to the extent that it's not already aware. So that's a change there. And also in relation to third-party harassment. So if you've been operating in this space for a while, you remember that we previously had provisions about an employer preventing or being liable for third-party harassment, and those were repealed. But under the Employment Rights Bill, an employer will be liable for third-party harassment in relation to all relevant protected characteristics. This is not just sexual harassment. So that would be if, for example, a customer or a client harassed an employee in the course of their employment and the employer had failed to take all reasonable steps to prevent that harassment. So depending on what sort of organisation you work in, if you're customer facing or if your staff are customer facing, then there might be further considerations that you need to be thinking about in order to how you will discharge your duty to prevent your staff from experiencing third-party harassment as well as harassment by any of their own colleagues. Sticking with equality, if we move on to the next slide, a quick word on equality action plans. It's going to be mandatory for organisations who have a duty to report their gender pay gap to develop, publish and implement action plans to reduce their gender pay gap. So it's not going to be enough for organisations just to produce the gender pay gap and add that to their website and their intranet, but we're going to have to go further in producing our action plans. And similarly, if we have more than 250 employees, we're going to have to develop and publish equality action plans dealing with supporting employees through the menopause. There's also, so not sitting within the Employment Rights Bill, but separately, there is talk of there being a new equality, race and disability bill, which will, among other things, introduce the right to bring equal pay claims based on ethnicity and disability, so moving that away from being purely based on sex, and also providing for mandatory ethnicity and disability pay gap reporting, again for employers with 250 employees or more. So that sits outside of the Employment Rights Bill. There isn't even a draft Equality, Race and Disability Bill available yet, so that is very, very early stages. And is a much longer timetable, therefore we would expect before we would anticipate seeing these changes coming in. But just whilst we're talking about equality, it's worth flagging that because I think that had been talked about, but it's going to sit outside the Employment Rights Bill. Right, enough from me. I am going to hand over to Katie and she'll take us through some of the other reforms.
Thanks, Fiona. Now, the Labour government's plan to make work pay contained little to no information or proposals in relation to trade unions and industrial action. But the Employment Rights Bill actually contains quite extensive proposals in this space. This could be a session in and of itself, but we've tried our best to summarise the key changes here. So the first kind of approach is looking to simplify the procedure for statutory union recognition. So some of you will be aware that the Central Arbitration Committee can handle a process where a union isn't recognised on a voluntary basis by an employer. And the move seems to be to kind of make that easier. So that the first change is that they're removing the requirement at the application stage for a union to demonstrate that there's likely to be majority support for union recognition. So that's going to be swept away. And the requirement for 40% support threshold at the recognition ballot stage, that's 40% of the bargaining unit. So the workers being in support of recognition will fall away. And similarly, the government's going to consult on potentially reducing the 10% application threshold for the arbitration committee to accept a trade union recognition case. So that's a requirement where 10% of the bargaining unit need to be trade union members. So if these proposals are implemented, then it's likely that that proposal is going to be easier. We might see an increase in statutory union recognition. The second proposal, again, is fairly extensive and it relates to giving trade unions a new reasonable right to access the workplace for purposes of meeting, representing, recruiting or organising workers or facilitating collective bargaining. Now, quite crucially, it's not allowing them access to organise industrial action, but it is quite a broad duty. The consultation suggests that there will be views sought on whether certain workplaces should be excluded. And it's not clear what that might cover, but it might be sort of essential services like hospitals or the ambulance service. But that's kind of open for debate at the moment, but we can see that being quite a key shift for employers if you're having to arrange for the union to attend. And we understand that a process will be set out whereby the union makes a request, and if the parties can't agree, it would be dealt with by the Central Arbitration Committee. The third change relates to your Section 1 statements of particulars that are issued to workers and employees. At present, there's only a requirement to set out whether any collective agreement affects the terms and conditions of the Section 1 statement. But the proposal is to shift that and require employers to actually inform staff of their right to join a union via the Section 1 statement and also regularly during employment. Now, most employers who recognise a union or at least work closely to a union will probably inform their employees of this, but it's quite a move for it to be a requirement in the Section 1 statement. So you might expect to see a rise in union membership as a result of that. There's also proposals in relation to giving union representatives sufficient facilities time and new rights and protections. This is also open to consultation, but one of the proposals relates to reasonable time off for trade union activities and includes a presumption that reasonable time off will be what the union representative thinks is reasonable. So we can see that that might cause a bit of difficulty. The government's also proposing to reverse the recent restrictions which were introduced, I think, just in May this year in relation to check-off rules. So that's the system for deducting trade union membership fees from salary at source. The new rules in May introduced some charges for the union to pay in the public sector, and Labour are looking to remove that. And there's a few additional recommendations in relation to removing the 10-year ballot requirement on political funds. So that's a requirement for unions to carry out a ballot every 10 years if they're proposing to use funds for party political activities. And Labour view that as outdated. And there's also some proposals in relation to blacklisting. So that's the notion that companies keep sort of blacklists of what they think are troublesome employees who tend to be union members. And there's a view that there needs to be some further legislation on that. We do have another slide on the trade union proposals as well, if we move on to the next slide. There's quite extensive proposals in relation to simplifying industrial action ballots. So this all came about in the Trade Union Act 2016, which was implemented by the Conservatives, and Labour is actually looking to repeal most, if not all, of that act. They're going to revert to requiring a simple majority of those voting for a ballot conducted by a trade union for industrial action to be successful, with no requirements of any level of turnout. So the Trade Union Act required a 50% turnout, and that's going to be swept away. The notice requirement for industrial action will be reduced from 14 days to 7 days. And the legislation, which added some further requirements for mandatory information on ballot papers, is also proposed to be removed. So again, it's this sort of movement towards making industrial action, I suppose, easier. But Labour have also been clear in their papers that they want to do this so that it strengthens the kind of negotiation between unions and employers, hopefully to avoid industrial action. They have proposed to repeal the legislation which allowed the government to require employers in certain sectors, it tended to be sort of rail and ambulance, NHS, to operate minimal service level requirements during industrial action. It's not clear whether those have actually been used in practice, but they will be repealed. Similarly, the Conservatives had introduced further rules to provide for supervision of picketing, and that's going to be removed. And the last 2 points here again are quite extensive. So the government will be introducing protection against detriment for taking part in industrial action, and that's to bring into force into UK law the Mercer case, which some of you will be aware of. So it wasn't explicit in UK law that employees were protected against detriment short of dismissal for taking part in industrial action. There was a Supreme Court case on that, and that will now be written into UK law. And lastly, on trade unions, the Labour government will remove the 12-week limit on the unfair dismissal protection for employees taking part in industrial action. So currently, an employee can argue that they are automatically unfairly dismissed if they are dismissed within 12 weeks of undertaking industrial action, and potentially unfairly dismissed after that period if the employer hasn't taken reasonable steps to resolve that dispute. But that 12-week limit will be removed, which means that there's more scope for unfair dismissal claims occurring after that 12-week period. So you'll appreciate there's lots to cover on the trade union front. But if we move on to the next slide, there's been some minor changes to statutory sick pay. The first being that the lower earnings limit, which is currently set at £123 per week, will be removed. So those earning less than that might still be eligible to receive statutory sick pay. And in that case, their entitlement to statutory sick pay will be based on a percentage of their weekly earnings. Now, there's a consultation ongoing just now, which closes, I think, just towards the beginning of December, into what that percentage might be. There's discussion about it being sort of between 60 and 80%, but that's not been decided yet. But I think the more crucial change is that the 3-day waiting period will be removed. Therefore, workers and employees can be entitled to statutory sick pay on day one of incapacity for work. And our sort of feeling is that that 3-day wait period probably disincentivized employees from taking short periods of absence if they weren't going to receive any pay. But now we might see an increase in absences if they're going to get some sort of pay, at least for the first 3 days and thereafter. Moving on to the next slide, then, there's been a raft of proposals in relation to certain types of leave and family-friendly leave, and also protection against dismissal. So dealing firstly with that, most of you will be aware that in April this year, the protection in relation to redundancy for those returning from maternity, adoption, or shared parental leave, the entitlement to have first refusal over suitable alternative vacancies in a redundancy situation was extended to the 18 months after you've returned from leave. That's still in place, but the government's also intending to introduce a new protection against dismissal for pregnant women and those returning from maternity, adoption, or shared parental leave in the 6 months following return from work. Now, all we know about this at this stage is that it will be a period of 6 months after the return from your family leave, and that you'll only be able to be fairly dismissed in certain circumstances. We don't know what those circumstances are or how those pair with the current potentially fair reasons for dismissal. That is open to consultation at the moment, and we'll await further detail on that. Unpaid parental leave will become a day one right. So that's your right to up to 18 weeks unpaid parental leave until a child turns 18. It's rarely used in practice, but the policy decision behind it was that employees can get best use out of this leave if it's granted as a day one right rather than something at 1 year's service. And similarly, paternity leave will become a day one right rather than a right that's acquired at 26 weeks service, ending with the 15th week before the expected week of childbirth. So there's 2 rights there that are becoming day one rights, and that was to bring those in line with your maternity leave and adoption leave rights. Interestingly, there was some press reports previously regarding making the right to maternity pay a day one right, but that doesn't feature in this bill, so it's sort of watch this space as to whether that's going to come to the fore again. There's a proposal to allow employees to take paternity leave and pay after shared parental leave. Currently, if a father or partner takes shared parental leave, they're not able to use paternity leave at the other end. And it was felt by Labour that it's better if employees can use the different types of leave that are available to them. And lastly, on this slide, there's a proposal to broaden the right to statutory bereavement leave to categories other than parents. So at the moment, parents whose child dies under the age of 18 or who have a stillborn child after 24 weeks are entitled to up to 2 weeks statutory bereavement leave at a prescribed rate. The proposal is to extend that to other relationships, but there's no detail on that. That's subject to consultation. So who will this apply to? But what we are told is that it won't impact the right to parental bereavement leave. So it will be a further right to bereavement leave in addition to that. And if we move on to the next slide, then another couple of sort of miscellaneous changes. The first deals with tips, which I'm sure most of you will be aware of. The Allocation of Tips Act came into force just on the 1st of October. and that requires employers to ensure that workers are paid tips, gratuities, and service charges in full. That's going to be amended to require employers to consult with representatives about those policies and when they review them. On outsourcing, there's going to be changes in relation to public sector outsourcing contracts and certain provisions that need to be held in there to avoid having sort of two-tier workforces with those who are transferred from the public sector and those who work for the supplier. And we've also flagged there's proposals to create a couple of negotiating bodies in the adult social care sector and school support staff sector. And if we move on to the next slide, in terms of enforcement, there's a proposal to have a single enforcement body called the Fair Work Agency, rather than this sort of fragmented approach that we have at present with the Employment Tribunal enforcing some claims and then areas like the National Minimum Wage Enforcement Team dealing with others. This is subject to consultation, so we don't know how that will work in terms of resources, funding, but we need to kind of keep an eye on that. I've listed some of the provisions that is proposed to cover. It includes statutory sick pay, which isn't something that's kind of enforced at the moment by a separate body. And on tribunal claims, it had featured in some of the press that there was a proposal to extend the time limit for bringing claims from 3 months to 6 months, which might increase the types of claims that we're receiving. But again, that doesn't feature in the bill, so we need to see whether that will be raised at a future date. And if we move on to the next slide, we've just flagged some of the other reforms that I'm sure you will have seen in the press, but that are not dealt with under the Employment Rights Bill. So we've listed those there for information. You'll have heard of, the right to switch off, etc. And on the final slide, we've listed again some of the longer term reforms. Employment status is a key one that received quite a lot of publicity, but we're yet to see further detail of that. So that's a sort of whistle stop tour of the 20 odd proposals, and Fiona is going to take us through some of the key takeaways from that.
Thanks, Katie. I mean, I think the key takeaways are basically, is there anything to do immediately? No, which I know lots of you will be delighted about. It's going to be a case of wait and see. There will be consultations, there will be further regulations to be drafted and to come out. So we will, of course, keep you updated in all of our usual ways about further developments in this space. In due course, there will be some work to be done in relation to policies and contractual terms, thinking about probationary periods and contracts and just how we manage people when they first start as an employee within our business, thinking about how we flex our labour and resources when we need to, and how that might work in the new world. But none of that can be done just at this moment. There are a couple of questions that have come in, and we can probably squeeze in two, because I think the first one, Katie, I thought you might want to take. It's pretty short, and it's about the fact that unfair dismissal is going to become a day one right, so there'll no longer be a requirement for you to have 2 years service, and whether that means that employees will also be entitled to a statutory redundancy payment from day one.
Short answer is no. So the statutory redundancy payment doesn't feature in the Employment Rights Bill at all. So that's still 2 years service for that.
Yeah. And then somebody has asked a question just about my comment in relation to unfair dismissal about the changes. Will it not make claims more complex because we'll end up with unfair dismissal and discrimination instead of discrimination only? I mean, I think the point is that quite often we see people having to try really hard to find a way to manufacture a basis for a discrimination or a whistleblowing claim because they don't have the qualifying service in order to be able to bring an unfair dismissal claim. They've not been employed for 2 years. So the expectation is that for people who would otherwise have had to try really hard to bring discrimination or whistleblowing when it maybe doesn't exist, they won't have to try so hard anymore because they'll have that day one unfair dismissal protection. Of course, if people have in a very short period of employment also being subjected to whistleblowing detriment or dismissed, or subjected to discriminatory treatment, then yes, absolutely, we would anticipate that those people or people in that category will bring unfair dismissal and discrimination claims. But we might see some of the more spurious discrimination and whistleblowing claims not having to be pursued anymore, is I think the point that I was trying to make on that. I'm conscious of the time, so we won't take any more questions as part of the session. But if there's anything in particular you would like to discuss, then you should definitely reach out to your usual Brody's contact. If you are a Workbox by Brody's user, then we have updated the site. You'll know that we have the team here that make sure that the content on the site is up to date. So Workbox by Brody's is completely up to date insofar as it possibly can be at this point in time, based on the Employment Rights Bill as it currently stands. And again, the team here will make sure that the site is up to date and that there are resources added as and when it becomes appropriate for us to start drafting new policies or new template documents, new contracts or contractual clauses. And otherwise, thanks very much for joining.